Thank you. Next witness, please.
Anthony Goldsmith for California. Sorry. Anthony Goldsmith for Californians Disability Rights. I want to echo Mr. Baker's statements and also thank the committee and staff for tireless efforts in bringing together stakeholders and proposing amendments. This Sunday night, our legislative committee met and moved our position from oppose to oppose unless amended with serious concerns. And the serious concerns were, even as amended, the bill addresses the issue of the disability rights litigation, as it's called, a crisis. Turns out it's a fraction of 1% of litigation in California. From a set of provisions that looks at limiting rights and remedies and extending time past the 25 years of the ADA, past the 40 years of California law, for creating additional time for businesses to comply with the set of civil rights laws which are of critical importance. We believe that to the extent there is frivolous or unnecessary litigation, the better approach to deal with those matters is in a fashion dealt with in your own Assembly Bill, Assembly Bill 1521, which looks at procedural remedies to limit litigation filed by persons simply seeking on a mass filing basis to acquire money damages without serving the public interest of obtaining injunctive relief. And that's why we supported the joining of the bills. I want to thank Senator Roth for tackling this issue. I want to thank the committee. I do want to say, however, that on balance, even this bill, given our serious reservations, in any way to create a neutral position, or I would say less than neutral of grave concerns position, would be through accepting the amendments that the committee proposed. I would like to just very quickly address a couple of issues Senator Roth brought up. First, since the inception of California's disability rights laws and their enforceability, they've been construction-driven, meaning that even when the code changes, and this is a common misconception, even when the code changes, which it does on a predictable 3-year cycle, you are not required to meet the new code requirements unless you build or alter. And I do not believe it is unreasonable to say that when people undertake something as serious as building a building, that they're expected to comply with disability rights laws, they're expected to comply with fire code, they're expected to comply with any number of codes that affect the health and safety of individuals. So I was concerned about the statement that we need to then provide additional time after something has been built for additional review. I think the remedy for that, for a prudent business owner, would be to hire a CASP or an architect qualified as a CASP, or make sure the architect signs on the dotted line that it's accessible and that there's some liability if there is a failure to complete and design in an accessible fashion. Another matter that was brought up is limiting to small business. We hear the narrative that the problem is mom and pops getting sued. And as Mr. Baker says, the small business language tracks the provisions from SB 1186 in looking at this as a problem where little businesses perhaps don't know enough to take care of themselves. Additionally, the issue was raised that multiple issues might be covered that a CASP didn't catch. Well, I think that kind of goes without saying that it's important that the facility is actually accessible. And having some experience both as an attorney and as an access consultant, I can tell you that unfortunately, as Mr. Scaff pointed out, the CASP program is a little bit on the Wild West side, and there are CASPs that are for sale who will tell people that a 5% slope in a parking lot is okay, who will walk right past a 2-inch barrier at a door. So I think it's critical, as the amendments put forth, that the area inspected by the CASP be compliant. I think that's the goal of everyone. Finally, the senator raised the issue that multiple CASP reports. Again, I bring this back. When a building is completed or an alteration is designed and constructed, that must be compliant. And I believe that he also stated that it would cover one and done for the entire building. I'm not a legislative analyst, and I'm not sitting in your seats, but I understand the way the bill is written is there could be different reports for different areas. And that is not a one whole facility where there's landlord-tenant liability and we're done. A store could do an interior and the landlord could do an exterior, and they would be limited to the areas surveyed for this immunity or amnesty, but that they would be able to do that by designating that information. So we were in the position of being able to oppose, unless amended to the committee's suggestions, staff's suggestions, and that is the position we can take, but with those reservations that the right way to approach the perceived problems is procedurally to get at the actual bad actors rather than substantively through moving against rights and remedies. And I thank you for your time and your efforts.
Thank you.
May I unfortunately have a district event, need to catch a plane, so I have to excuse myself, but seeing the tenor of the discussion, I'd like to make sure before I leave that I move the bill as Senator Rothers presented it without amendments.
Well, I'm actually going to ask that, given the fact, which was a fair concern, that the amendments, the Senator didn't have as much time to go over. From what you had said in your statement, I think there's plenty of room for you and I to be able to talk about this and come to an agreement on it. So I'd like to hold this item over until next week, give us a chance to talk, make sure that committee members have the ability to see what exactly the amendments are that the stakeholders do as well. And I think just based on what you said, I think there's room to come to an agreement. The work that's been done, Senator, by you, by all the stakeholders, by the committee, work that was done in the Senate, this just seems an awkward place to stop, to have such a go, no-go decision. I'm not really willing to do that because I think you and I can come to an agreement. So I'd rather hold this over and make sure that we get it right as we move this.
Mr. Chair, if I may, that's perfectly acceptable to me. The only complication, but it's a complication over here that perhaps you and leadership can help with, is this matter is dual referred to Revenue and Taxation, and it's my understanding Revenue and Taxation meets on Monday and Judiciary meets on Tuesday, so that's an issue that I assume can be worked through the Rules Committee here.
We'll work on that. Absolutely. Absolutely.
Can I withdraw the motion?
All right. Thank you. Thank you. All right. And that gives you some latitude. Good. All right. Next witness, please.
Chair and members, Evelyn Abu Hassan with Disability Rights California. We're a cross-disability organization. We are in opposition to the bill in its current form. I'd like to align my comments with Mr. Baker with the ACLU. We have worked hard to come to some agreement with the proposed amendments, and had the amendments as presented today in committee been adopted, we would have been neutral on the bill. I have been working this issue for 15 years. And not only have I been working this issue for 15 years, I'm a person with a disability that faces access problems every day in the course of going out into the public and dealing with these issues. This is about our civil rights. And so as we talk about these issues, we have to be cognizant of that. We have to be aware that we're all working to get to a place that's workable for both parties. I think these proposed amendments got us there. We are certainly open to continued dialogue, and we are a bit disappointed today that we couldn't have accepted the proposed amendments as the committee had presented them. Certainly we're willing to continue the discussion, but at this point in time, we oppose the bill in its current form. Thank you.
Thank you. Next witness, please.
Thank you for this opportunity. I'm Holly-Ann DeLille, lifetime member of Californians for Disability Rights, member of the Board of Designing Accessible Communities. And I want to ask that you consider something that hasn't been discussed yet, and that is, as you're crafting this bill, and that is the fact that there is real damage done. I think there's a tendency here to gloss over the damage that discrimination does. And there's a great deal of body of law, I understand, that totally recognizes and describes the damage that people suffer when they are discriminated against. It does deep, visceral damage to your self-image, to your idea of your place in the world, and just to your whole personhood. And this bill wants us to ignore that damage. And And when that happens, that is saying to the world that people with disabilities have no value, that we in the state of California recognize and give no value to the damage done to people with disabilities when they experience discrimination. And that's something that we're going to have to fight with everything that we have, because it doesn't help anybody, because anybody can come into a disability at any time. And you don't want to come to a situation yourself where you face discrimination and you face being devalued, and it's sanctioned and codified in California law.
Thank you.
1/2 of all these access cases are only 1/2 of 1% of the cases in California. So why is there this witch hunt against people with disabilities? The crops have failed, and you've got to find somebody to blame, so you go after the cripples. Please consider what you're doing to people. We're people. We're not something less than, subspecies, subhuman. We're just like you. We're Americans, and we have value. Thank you.
Thank you. Next witness, please. And we're going to be holding this over, but we're happy to take your testimony at this point, and we'll take testimony again when we hear the bill next week. And if people could be brief, we would appreciate it.
Thank you, members of the committee. My name is Connie Arnold. I'm from Elk Grove, and I have a letter that I wrote that I'd like to hand out to each of you. I did fax it yesterday, but I don't know if you saw it, but I wanted to personally deliver it to you.
Thank you.
I am total agreement with all the speakers that have presented the problems with this bill. I am not responsible for enforcement of access laws, but the only way of enforcing these laws is through litigation. And even if there are a few problem players out there that aren't getting access, you also have defense lawyers that are pushing issues too, that they want to delay settling a case over injunctive relief so that they can get more legal fees out of a case. You also have a problem where they want both sides. They want to say, well, why can't we just pay attorney fees and damages to some plaintiffs, certain plaintiffs? And on the other hand, they want to say, oh, well, these people aren't getting injunctive relief. Well, the real truth is that enforcement of these laws that have been on the books for 30 years is left to people with disabilities. There's no real enforcement. You've got building officials passing buildings, as you heard, brand new buildings like La Brisa in a resort in Carlsbad, California, with a 3-inch lip in a roll-in shower to make it completely unusable for a person with a disability. This has happened over and over. New buildings are not accessible. Old buildings are not accessible, and everybody wants a pass for a few more days and reduce damages after people with disabilities have been discriminated against. And I should not be treated like a second-class citizen in society. I'm a citizen of America. I was born here. I want the same equal access as everybody else. I'm very passionate about this issue, like a lot of people, because basically I'm an American, okay? I want the same legal rights that they're passing to make improvements for lesbian and gay individuals and in society, and for African Americans. I want the same access. Separate but equal is not equal. I want access to bathrooms, parking, facilities, public and private transportation, and I don't have it. I can't even find accessible bathrooms half the time. It's like beating your head against a wall. I know I'm supposed to be brief. It's hard to be brief when you just try to use a bathroom even in a hotel across the street and it's not accessible. They put a riser on the toilet seat that made it actually higher than the legal limit, so it made it extremely difficult. These things are the situations that we face, and these are day-to-day barriers that we face. I appreciate that you're going to consider making changes with amendments, but in any case, I still feel like this is a bad bill, and removing the civil rights of persons with disabilities is wrong. If Senator Milton Marks was alive, he would have the rights on the Committee on the Rights of the Disabled, and he would be taking our testimony, and he would be listening to what we said. And it was George Bush that passed the ADA, and that was a great thing to our community. And ever since it got passed, it's been how can businesses get rid of this? How can they get rid of the disabled? I don't want to be reincarnated as a person with a disability because I don't want to face the ongoing discrimination that I face every day of my life. Thank you.
Thank you.
I vote to oppose this bill. Thank you.
Thank you. Next, please.
Hello, my name is Patricia Doucette.
She's going to go and then you're on your turn.
Hello, my name is Patricia Doucette, and I'm a title holder for the Miss Wheelchair California Pageant Organization, Incorporated. And I oppose the bill. I've only been disabled for 6 years, and I wanted to speak on this because I agree with what everyone's been saying about the disabilities. And it is hard. And like I said, I've only been disabled for 6 years. I had a stroke on the job. I was working law enforcement, and it is really hard being disabled. And I couldn't even imagine being disabled my whole life. But trying to work a wheelchair and trying to get through doors, barriers, and whatnot is extremely hard. And trying to get in bathtubs and having a lot of access problems is extremely hard, and we really do need help. And we really need the help. If you can do that for us, that would be great. But I oppose the bill at the way it stands now. And that's all I have to say. Thank you very much.
Thank you.
Good afternoon. My name is Warren Doucette, and I oppose SB 251 in its current form.
As she's making her way up, maybe we can get...
Henry Contreras with the California Foundation for Independent Living Centers. We thank the chair and the committee staff for their hard work on the amendments. We took and opposed on the less amended position, so we will continue to work with you to see if we can come up with an agreement.
Great. Thank you. Yes, ma'am.
My name is Terry. And 40 years ago, I came into this building to try to make it accessible. At that time, we took the senators, and as I recall, there were no women at all, just men, and we said, gentlemen, see if you can get a drink of water, make a telephone call, and take a leak. And you know, they couldn't in a wheelchair. None of the bathrooms were accessible. None of the phone booths were accessible. The whole building wasn't accessible. And we said to the senators, and I remember one, Bill Green, and he said, we'll make this building accessible. And we said, no, Senator, we want to make this state accessible. Now, I'm currently serving on the committee, the Disability Committee at the University of California at Davis at the Sacramento campus. I've worked on disability access for 40 years. The CATS program stinks. They were all right. I'm deaf. I could hear very little of what was going on. You do not have real-time captioning, as some of your committees do, and it's a wonderful thing because I can look up and see what people said. I don't know much of what has been going on, not because I'm stupid, not because I'm 80, but because I'm deaf. I'm late deafened and I don't sign. I worked on the accessibility of this building to make sure the bathroom was accessible because they kept forgetting, oh, is that important? I'd say that's the most important thing. If you can't go to the bathroom, you can't do a whole lot of legislation. This state, many years ago, was in the forefront of disability rights. You passed legislation which the entire country followed. We took that opportunity because we knew California was the best state in the country. It was then, it still is. And we knew that we were the leading edge, we were the cutting edge. You still are. And we knew that what we did, the country would follow. The first thing we brought up in here was Section 4500 of the Transportation Code, that all mass transportation shall be accessible. Doesn't mean much to you, but it meant a lot to us because the gentleman was talking about Selma. Hell, we couldn't even get on the bus.
Thank you, ma'am. I do need you to wrap up.
The reason that we needed Section 4500 of the Transportation Code because we didn't trust the feds. It was in the federal regulation. And, of course, the next president who came in cut it out. But we had it in California. And that means California has the best transportation system in the country because we fought for it. This bill stinks. We've had 40 years of shilly-shallying and dilly-dallying and, oh, we don't need to make it accessible. The people who argue about making money available for access are the same ones who claim about all those people who are collecting disability and all those people who aren't working. Well, why aren't they working? They can't get in the building.
Thank you.
And that's the reason that we need access. We need it for education. We need to raise our kids and all those reasons, but we need jobs. And every time you say, oh, well, we have 90 days to fix the building. You've had 40 years. This state needs to get back in the front of disability rights and not at the butt end. Thank you.
Thank you. Please hold your applause. Thank you. Next witness, please.
Mr. Chair, members of the committee, for the record, my name is Peter Mendoza, and I reside in Marin County, California. I am a person with a disability who is employed, and I do my best to fully participate in all aspects of society, and I'm not just about disability rights. I'm involved in many other aspects of community life and give a lot back to the community and pay taxes in the process. But I am affected by places that are inaccessible, and it is a significant barrier for me to live independently, be able to work, and to be able to give back to my community the way that society wants us all to, and the way that we all have the right to. And I do respect what Senator Roth, opening up a dialogue, but this is the wrong way to go. What we need, if you want to curb disability access lawsuits, is a partnership with the business community working together with us to make business accessible. That really hasn't happened. We need to come together and really talk about the issues and really come to some resolution that's meaningful. We also need more enforcement by local building officials. That doesn't happen either. One of the problems that I run into quite frequently is I see new construction that's completely not accessible. And there is no such thing as a minor violation. Signage is important, for example. Ms. Arnold, who testified previously, and I were going to attend a church in Marin County. It was a little bit dark, and there was no signage to indicate where the ramp was. I saw what I believed to be a ramp. I started to go down what I thought was a ramp. It was sort of an incline. It turned into stairs. I went down the stairs. My wheelchair stayed up. I yelled for Ms. Arnold to stop so she wouldn't get hurt. It turns out there was a ramp, but there was no sign and not enough light for me to be able to find it. It's really discouraging when you talk to building officials about access violations, and they go, "Peter, there you go again. You're all about, we're doing the best we can, but they're not enforcing the law." Then you talk to the mayor or the city council people or the board of supervisors, and they pass the buck or in some cases they try to get you to drop your complaint, or they talk about how the small business goes through enough and they really shouldn't have to make any improvements to be accessible. I'll close by saying I don't want to be the only protected class that doesn't have the same rights as everyone else. Don't lessen our rights because there's a problem with access. Correct it the right way by passing legislation to hold more cities, counties, and public entities accountable. The Business Association needs to come together and work with us, not just fight against us at legislative hearings. Thank you.
Thank you. Please, if you could hold your applause. If you would like to show consent, wave a hand. We'll notice that. But I'd like to go to the next witness, please.
Yeah, my name is Mark Vasquez, and I'm from Sacramento, and I oppose the bill.
Thank you. And you have flags to wave, so that's great.
I noticed when we started it was morning, and now it's not. Thank you very much for all the time that you've given. My name is Ruthie Goldkorn. I'm, aside from being with Californians for Disability Rights, I am the chair of the Democratic Party Disabilities Caucus. We have taken an opposed position. I stand with the oppose unless amended position from the caucus as well as CDR. Bills that are founded upon the basic premise that we must punish the victims are wrong. People who are discriminated against are victimized. We are told, we don't want your kind. We don't like your kind. Very subtle, subliminal messages come through when there are barriers. Businesses are not stupid. They know that they see people every single day struggling with the door, whether they have a disability or not. That means it doesn't comply. They see people struggling in their restroom facilities. That means it doesn't comply, and they choose to have a blind eye. Any law, any bill, any premise that is based upon looking at the primary users of a facility or a business or where they work, where they play, where their kids go to school, and you say to them, gee, I'm really sorry, come back later. That is a violation of the Civil Rights Act of 1964. It seems to be perfectly fine under 1186. It seems to be perfectly fine under 251. No. Ladies and gentlemen, please consider the human cost. These amendments have serious consequences. They do not solve problems. They create more. The amendments that we know about, the amendments that we worked on, made the bill possibly, maybe, palatable. But the arc to future legislation coming back every 2 years, we're here. Why? Because we're not solving a problem that doesn't exist. The chambers of commerce, tort reform lobbyists, hysteria over litigation. 0.5% of the litigation in California has to do with one demographic. That is not a crisis. The fact that maybe there's a percentage of people who are not getting the job done and getting access, address that. And 1521, I know, is supposed to be addressing that, and we are very, very appreciative of the work that this committee has done and the work on the amendments. The problem is not us. We have a problem. We are not the problem, and yet our degradation, humiliation, embarrassment, what we have to go through with our kids or in front of our kids or on a date or with our girlfriends on a girls' night out, has value. We have value, and that is why civil rights statutes carry damages, because the value of your human being presence is to be recognized. Please, ladies and gentlemen, I realize that we're coming back, and I appreciate that, Chair Stone, but this bill is going in circles, and we've been going in circles for almost 10 years. Solve the problem that you perceive, leave the disability community alone, go after the linchpin. Thank you.